You're listening to the Max Planck Lawcast, which showcases the academic research currently being conducted across the Max Planck Law Network. I'm your host, Christopher Murphy, and together we'll be talking to some of the more than 400 researchers who are pushing the frontiers of legal knowledge in Germany and abroad. When it comes to new and exciting legal research, the Lawcast has you covered. Well, thank you very much for tuning in to what is actually the first ever podcast here on the Max Planck Lawcast. It's wonderful to have you here with us today. And the aim behind the Lawcast is basically to travel around the 10 different institutes that make up the Max Planck Law Network to talk to researchers and get an idea of what they're researching at the moment. So the research at these institutes is very different. No episode will ever be like the last, but I think that's what's going to make it particularly interesting. So without further ado, let's begin. And on today's episode, we're going to be talking about recent reforms concerning the offence of rape, with a particular focus on non-consent to sexual conduct. More specifically, we're going to broach the issue of how non-consent is interpreted and why, as a legal concept, this can pose a range of challenges. To do so, I'm happy to be joined in the studio by Cristina Valega Chipoco. Originally from Peru, Cristina is currently a doctoral researcher at the Max Planck Institute for the Study of Crime, Security and Law here in Freiburg, Germany. Welcome to the program, Cristina.
Thank you very much, Chris. I'm happy to be here.
Well, I've said a lot right now, and I think I'll probably give it over to you now. Maybe could you start by providing a brief overview of recent trends concerning the offence of rape and the constituting elements?
Of course. Just first, as a content warning, mention that we're going to discuss today and speak about sexual violence, sexual offences, topics that might be difficult. So just to mention that at the beginning.
Okay, absolutely.
Thank you very much. And I think you are speaking about a very important topic to start. And I want to start with a phrase from a Spanish professor. She's called Maria Calle. And she says that it is not the act of violence that shows the absence of consent, but this last that reveals a sexual conduct as violent. And I think this phrase summarizes many of the legal trends that have been happening around the world in the last decades. Because what this phrase says is that before and still today in some legislations, the rape offense was understood as committed through violence or threats or serious attacks to bodily integrity.
Force, in many
Exactly,
ways. Yeah.
Force, coercion.
Mm-hmm.
So when you had a case, there was always a question, and still is in many cases, of how was the violence committed, what was the threat to the survivor victim, or looking for these elements, instead of asking the question of was it a consensual act? And paying attention to the autonomy that people have to engage in these interactions. So we don't need to search for the violence or for the coercion or for the threats. Now the trends say that we need to search for the element of consent. Was it consensual? Did the people were willing to interact sexually? Did they communicate this? So the trends have gone in that direction. For example, in Europe now and 13 countries and worldwide overall, different countries, for example, also Honduras or the United States Model Penal Code, have adopted this transition, leaving behind, at least by statute, the coercion-based model or duress-based model traditionally, and transitioning towards a consent-based models. So they've modified their rape offenses to include this, what we've been talking about. And I think it's also important to mention that this transition is happening in terms of domestic legislations, but also at the international level. For example, we have the Istanbul Convention in terms of the European system of human rights. We also have a recent judgment from November of last year from the Inter-American Human Rights Court that state that their signatory countries, states, have to consider the element of non-consent as the central axis when criminalizing sex offenses, leaving behind these other requirements of coercion and violence. So I would say this legal trend, to call it somehow, it's happening at different levels and it's been happening for the past decades. But of course, we still have a long way to go.
Mm-hmm. Okay, so there's basically then currently across the world in various jurisdictions, there's two primary models, the duress model based on violence, duress, and then there's the newer model which has been developing in the last few decades based primarily upon the idea of non-consent to a sexual act. As it seems to be that that's now becoming more and more the trend, as you said, let's maybe focus more on how exactly non-consent is defined.
Yes, Chris, thank you very much for the question, because I think, as you say, there is consensus nowadays that non-consent should be the standard. Of course, there are also critical positions toward this. For example, some academics say that is too liberal of a standard that doesn't consider structural discrimination, or other critiques that I think are also important to take into account, and we can talk about them later perhaps. But there is a strong consensus and movement towards considering non-consent the central element. But I think the discussion is still on, okay, this is what we consider a central element, but what does consent or non-consent mean? And how should we interpret it? So, for example, there are some legislations or some theories that state that consent is a mental state. So what the person wants or is willing to do. There are other theories that say that is a behavior. So what do you show?
Okay.
Do you manifest that you assent? Do you manifest that you don't want? But is that connected to your will, or is that more your actions or what you say? Should consent refer to unwantedness, ambivalence? Should it be clear, very clear? Also, there are approaches that state that in certain cases, consent is invalid. For example, when a person is intoxicated, age has been always recognized as one of the elements for capacity to consent. What happens if someone consents because they are deceived?
Okay, yes.
Or because they lack certain information? Are all deceptions, for example, capable of vitiating consent in a legally way of understanding it, or perhaps only some of them? And also, I think one important approach towards consent is the yes means yes approach and the no means no approach.
You hear these two approaches, the no means no and the yes means yes approach, talked about in the media. But for myself and for the listeners, maybe you could distinguish between the two models and what actually no means no and yes means yes means.
Yes, of course. So, for example, if we start with the yes means yes model, this approach assumes that non-consent is what we should assume. So consent needs to be sought. Either we need to ask the people that are participating if they consent to participate in the sexual interaction, or this needs to be shown somehow previously to the interactions. It also states that consent is specific to certain actions, so we need to constantly seek consent or participate to make sure that the persons are participating voluntarily. Mm-hmm. So it takes non-consent as the basis, and consent is something we need to seek, communicate, ask for.
Understood.
And in the opposite, we have the no means no. And the no means no actually starts from the opposite. So it says that if someone doesn't want to participate, then a no or a show of unwillingness to participate is what shows that the person doesn't want to consent. So it's not that you need to seek constantly or actively or previously for consent, but you assume that the persons are consenting and you have a duty to communicate your unwillingness if you don't want to participate.
So that means that in this case, you picked up on an important word there. It's the duty. That seems to be an important differentiating factor between the both models.
Exactly, because if a person is not willing to participate, with the no means no, you need to communicate that. Whereas with the yes means yes, we need to be seeking consent from the persons that are participating. Mm-hmm. Okay. Of course, important is to say that the models don't work alone. For example, if we then speak about different legislations and jurisdictions, we're going to see that a model can be the rule that a country takes on, but there might be some exceptions when consent is not, for example, it's not possible to give, or the unwillingness is not possible to be communicated.
Okay.
So these are like general approaches and models, but
right. And
one
they
can
have to be fine-tuned to each jurisdiction.
Exactly.
Okay. Jurisdiction, that's a good point to go to next then. Could you maybe provide 2 examples or an example of each model in a country? The no means no and the yes means yes. And maybe give a little insight into why a country would tend to choose one model over the other.
Of course, perfect. For example, if we start with the no means no model, I think Germany is a good example. So Germany changed its offense of rape in 2016 in the context also of adapting to the Istanbul Convention that we mentioned before.
And they moved away from the
duress-based
model. Okay.
Yes, that was based in coercion, as we spoke before. And they adopted the no means no approach. I'm going to mention a little bit how it's regulated so that it's clearer. For example, Germany states that the act that is carried out against the discernible will of the person, and of course, then it's regulated, the act of sexual nature and all of that. But basically, the act needs to be carried out against the discernible will of the person.
Right.
So this is, I think, a clear example of what we were speaking in the previous question, right?
That's right. Yeah. The duty, or in that case, is on the person to say, no, I do not want to conduct this act.
Exactly. Or to show it somehow. For example, Germany also gave the example of if someone is crying. You know? So you either communicate the no means no, and it's enough a no. Again, this is a transition because now you don't have to show that there was violence or coercion. The no is enough. Or also certain actions that show the discernible will that the person does not want to participate. Okay. Exactly. And I think it's also important to mention that Germany has some exceptions to this. For example, if there's coercion, you don't need to search for a no. If there's coercion, it is assumed that there was no consent.
Okay.
And other exceptions or examples of particular circumstances. But the general approach is the no means no. And you are asking, why does a country select this approach?
That's right.
I think something that I value very much about the process here in Germany is that there was a discussion on which model to take on, how to regulate it, because in other...
So a discussion within the media, within politicians, within society, broader debate?
Yes, within the politicians, in the academic level as well, and also in the media, I would say. And when I've reviewed, for example, the debates that happened in the legislative, in the parliament, are also from the commission that evaluated the proposal. So they speak about, okay, what are we going to incorporate in this offense, and are conscious about the model they are selecting. In some other countries, there's been this transition to include consent or non-consent, but not really a discussion on how to interpret it. And I think that's very important, that when the decision is made on how to regulate consent or non-consent, these other areas on what does it mean are considered.
Okay.
Right. And Germany, for example, there was a whole discussion on how to translate consent, non-consent. There's also a bigger debate on consent in criminal law in general, not only in sex offenses. So there was this proposal of not to use the word consent in the regulation, but better to state against the discernible will of the person, so that it's clearer how to interpret it. And also there's this strong position in general within criminal law and criminal law principles that criminal law should be ultima ratio and not a very expansive part of the law, because it should only punish the most serious actions and crimes. So that's also part of the reason why
so there's obviously a lot of thought that went into the process then.
Yes.
Okay. And a jurisdiction that also put thought into the process, but ended up going the other way with the yes means yes?
Yes, totally. So I think we could speak a little bit about Spain and a little bit about some states in Australia. Okay. So Spain, I think it's a very interesting case model. They changed their legislation last year in 2022. And what they have included in the offense is that whoever carries an act without the person's consent will be punished. And then there's a definition on consent, and it states there is consent when it has been freely expressed through acts that, in view of the circumstances, express the will of the person.
Mm-hmm. Okay.
So here...
There's much more need for definition there.
Yes, exactly. And this that you are noticing with the offense, I think happens also in a few other cases, for example, in Iceland. But here, the specific detail is posed on the fact that consent needs to be expressed and freely expressed through acts or that include behaviors or words. So if we analyze this statute, I'm of the position that it's the yes means yes model because it states that consent needs to be expressed.
Okay.
So it is not assumed and non-consent is that needs to be expressed, but it is consent that needs to be expressed. And if we speak about context, for example, in Spain, some years ago, there was this very well-known case that's been called La Manada, of this woman that was a victim of rape by what is called a gang rape in a big public event.
I think was that referred to the wolf pack
yes.
case? Yeah, okay.
Yes, the wolf pack case. Okay. Thank you. Mm-hmm. And so there were a lot of movements and social pressure so that the legislation could change. Because Spain before had two different offenses, one that regulated non-consensual sexual acts and one that regulated what we could call rape and required for violence or threats.
Okay.
So the social movements were saying non-consent is enough, we shouldn't make this difference.
Yes,
this is part of the reason why this case was not considered as rape when it should have been.
Okay. So there was also a lot of societal pressure in that instance too. We need to make a change here, and maybe we need to not put it on the position of the victim. Okay. So what you're suggesting is that there is taking the movement is taking off the burden on the victim and more saying to the offender, you have to prove there was no consent.
Exactly. That there shouldn't be a difference between different offenses, non-consensual, violence, that non-consensual should be the threshold for rape. And there was this whole debate also at the societal level.
Don't go away, because we're going to have plenty more for you after this short break.
Max Planck Law is a network of 10 Max Planck Institutes engaging in legal research. The first of these was established in Berlin in 1924. Today, we cover a broad range of legal studies, from the anthropology of law to tax law. We operate one of the world's largest programs for doctoral and postdoctoral research in law. Visit our website today at law.mpg.de.
Welcome back to the Lawcast. Thanks for listening to us today.
I think in Spain also something that is important to consider is that there's been more legal discussion on structural discrimination, gender structural discrimination, like in Latin America, that has not been that much the case in Germany, for example, because societies are also different and the experiences that societies have had. But actually, I wanted to speak a little bit about Australia as well.
Yeah, certainly.
Because in Australia, it's also happening that the different states are changing their interpretation on non-consent, rape, and also on the models.
Okay.
And for example, there's a discussion now going on that it is not only necessary to state in the offense that consent needs to be given, because that could also lead for some interpretation on that it could be the no means no approach. But so there's push to change it to consent needs to be agreed on.
Oh, okay. Oh, right. Okay. Is that a third model then, or is that somewhere in between?
Yeah, I think it's kind of on a move to guarantee on a statutory level that the yes means yes approach is also interpreted in that way.
Okay, right.
Because, for example, the Istanbul Convention states that consent needs to be given, freely expressed, but it can also be taken on in legislations as consent can be included from the no means no approach.
Okay, yeah.
So that discussion has been going on in Australia, and I think it's very interesting because we could say that statutorily Spain is within the yes means yes approach,
Yes.
but perhaps in jurisprudence it is interpreted in specific cases in a different way, right?
Okay, yeah, sure. Okay.
So I think that's also important to say. A country can assume statutorily an offense in a certain way, but then also jurisprudence or academic interpretation debates can go in different ways.
100%, yeah, okay. We can be happy that the debate in general is moving in a positive direction here. But do the two models have any certain advantages or disadvantages?
I think that's also something very important to discuss, as you mentioned. For example, if we speak about challenges, perhaps points that different academic or theories or social movements are making on each of the debates, perhaps we can mention some of them. With the yes means yes model, for example, Professor Steven Schulhofer, which is one of the legal theorists that has written and discussed more about consent, I would say. He was also in charge of and still is, on the reform on sexual offenses for the US Model Penal Code.
Okay.
And for example, he says something that I find very interesting. He says that one of the advantages of the yes means yes model is that in most scenarios, a presumption of disinterest of sexual interaction is more accurate than a presumption that people want to be involved sexually, which is the presumption of the no means no model. Mm-hmm. Another point that I also think it's important is that I believe that non-consent is not too high of a threshold. And sometimes that is said within the discussion in criminal law. It is said that non-consent is within the yes means yes model.
Yes,
to seek consent might be too high, that we should consider that people can also communicate their unwillingness. But I think it is not too high because we are not asking for desire, we are not asking for wantedness, we are asking for consent. And the search for consent, I think it's not too high legally of a threshold and allows us also to respect the right to freedom and free development of personality, because that way we are certain that we are not infringing these rights of the other person.
Okay, sure.
But on the other side, for example, Professor Tatjana Hörnle here from Germany, from the Institute as well, she poses a question to the yes means yes model. She says, why state that something is rape when the complainant or the survivor victim was silent or passive in situations where communication would have been possible? So she poses that challenge, and I think it allows us also to go and discuss the no means no model. Mm-hmm. Some advantages that have been stated also by Professor Hörnle, for example, because she has written and discussed on this also because of the Germany legislation change.
The reforms that happened in Germany, yeah.
In 2016, in regards to the no means no model, she makes an important point. She says that it respects the principles of the criminal law system of ultima ratio, in dubio pro reo, and it allows for ambivalent situations not to be considered as rape. And also, she mentions that criminal law regulates highly selective interactions between citizens. So in that regard, it is important also that people have self-responsibility and consider its duties. Mm-hmm. As a counter-argument for this, I think it's also important that we know that in certain interactions, people are in a situation of vulnerability. And perhaps not everyone can communicate their needs, what they're willing, or can articulate that directly to the other person. That's also something that one professor here from Germany, Professor Torrens, mentions and uses as a criticism towards the no means no model, that we are assuming that everyone can articulate and communicate. And perhaps there are certain vulnerable positions that are not considered. Of course, within the German debate, it could be said, okay, we have tried to consider those vulnerable positions as the exceptions of the model. Mm-hmm. But I think that is still valid because something that I feel and think that sometimes the criminal law system doesn't consider is that there are important differences between citizens and persons like access to education, structural discrimination, backgrounds.
Societal differences.
Exactly. And that we are all not the same or neutral human beings. Of course, I understand that still needs to be limited in the discussion, because we do have duties and responsibilities and accountability. And it's also part of the argument that we can hold another person accountable as a perpetrator. But I think it's an interesting discussion in terms of the challenges of the both approaches.
Sure, a broader discussion as well. Yeah.
Yes.
When we're talking about consent or non-consent, obviously there are certain cases where it will not be of issue. It will be clear there was consent or there was no consent. Could you maybe provide us with a couple of examples of cases where non-consent currently is a trickier issue based upon the facts of the case?
Yes. I think that's perfect, because it also allows us to see in situations what this theoretical discussion brings, right?
Yeah, that's right. The law on the books, but then the practice is obviously,
Exactly.
vary.
Yes. For example, I would think of 3 or 4 situations. If we're talking about people that have drunk alcohol, or if one of the persons is drunk, does this vitiate consent? How is the person, or when, right? When is the moment when we consider a person cannot give consent?
Can no longer consent because of the intoxication.
Exactly. Yeah. So there the discussion would be what elements vitiate the capacity to consent, and in terms of intoxication, what duties could we ask for the people that are part of the interaction? Should we assume that non-consent can be given? And in that case, for example, what happens if the person argues that they could give consent and they gave consent? So it allows for a whole discussion also on negative and positive sexual autonomy, and of course also to guarantee the rights of the person that is in a situation of vulnerability because of alcohol. Another case could be the case of stealthing, so non-consensual condom removal.
Okay.
In that case, for example, that deception vitiate consent if the persons agreed to involve with the use of a condom and one of them didn't use it or lied about it.
Or removed the
condom it,
during
exactly.
Activity. Okay.
So what deceptions could also vitiate consent? Should all deceptions be considered? Only some of them? I think that's also a very interesting and important question. For example, if someone lies about their fertility or infertility, can that also vitiate consent for the sexual interaction? And also, I think another important discussion is in terms of non-disclosure of STIs, sexually transmitted infections.
Yes.
Some people or some part of the discussion say that that's also an important information to make a decision whether you want to engage sexually or not.
That if you didn't know that there was a danger, you would not have participated in the act.
For example, but at the same time, I think it's also important to consider the person living with the STI, their rights.
Okay.
For example, the right to privacy, the right to equality, the right to integrity, if they're in a situation where they could be suffer a stigma or even possibility to be harmed.
Maybe consider choosing one of those topics so that we can look a little bit more precisely at how non-consent is dealt with and what the elements of such an offence would be.
Yes, I think perhaps we can speak a little bit about non-consensual condom removal or stealthing. To start, it's important that we define it somehow. So non-consensual condom removal or stealthing, that has been more discussed also in the past years, is when people agree to have a sexual interaction with the use of a condom, but whoever was supposed to wear it doesn't wear it, or, as you mentioned before, interrupts that use. So the question here is, does this act of not wearing the condom that was agreed to be worn or interrupting the use of the condom, does this act vitiate consent? And if it vitiates consent, does it vitiate it in a level that makes the sexual interaction sexual violence or rape?
Yes.
And then I think this also brings more questions in terms of which deceptions should be legally considered or even by criminal law.
So in this case, how would the non-consent approach apply to stealthing?
Yes. For example, I would like to comment perhaps on some specific cases or jurisdictions that have had some cases. One of the first ones I would say was in the UK in 2011.
Yeah.
It was an extradition case. So in the end, it was not analyzed in detail to convict someone, but it was analyzed if the act of stealthing in that specific situation could constitute rape under the England and Wales legislation.
Right, okay.
And in that case, actually, they stated that, yes, it could have constituted rape. Of course, that was then for the other jurisdiction that was asking for the extradition to analyze in the specific case.
Okay. Mm-hmm.
But I think it raised up the importance of speaking about these situations and how they could vitiate a freely given consent, which is how the UK regulates it. Mm-hmm. There was also a case in Lausanne in 2007 that considered that stealthing could be rape. Canada in 2014 of a man that had poked holes in a condom, also considered it. Germany actually also had a conviction in a case of 2018. And recently, Spain had a case also in 2020 and then confirmed in 2021 that considered also the case of stealthing as rape.
Okay. And these are based on the consent models then?
Exactly.
And obviously on the yes means yes and no means no consent models, they're all reaching the same conclusion.
Yes, actually Spain analyzed it with their previous legislation, but they had a non-consensual sexual offense that was differentiated and they analyzed it through that one. And also Australia now, that we talked a little bit about before, is also within the states having this change to include stealthing explicitly in the statutes.
Okay. But then that's a question of how, they can include stealthing in the statute, but as we say, the variety of activities that can occur during a sexual engagement, you obviously can't include everything in a statute, is that correct?
Exactly.
Yeah.
And I think you're raising a very important question there, because then the legal question we need to ask ourselves is, okay, so in this case, this was a deception of a condition that was previously agreed within the participants. Mm-hmm. Do all deceptions that are previously agreed have the capacity to vitiate consent? And then therefore, are they rape? And can we recognize them as so from a criminal law basis that most likely ends up also being in a privation of liberty of someone? And for example, Professor Ivo Cocavilla, that's also here at the MPI in Freiburg, he's written an article and discussed this topic, and he considers that in the case of stealthing, it is a deception that can vitiate consent in this level and make it an act of rape because of the degree of bodily interference that happens. So if people agree on certain degree of bodily interference, if then someone violates this agreement, then it should amount to rape.
Yeah. My final question for you is, where do you think the discussion will go? We've talked a lot about where the discussion's been, past and present. Where do you see the discussion about non-consent going in the future?
I think definitely it will keep going towards a consent-based model. So there are many countries that still have not considered or had this transition. I think also there's more questioning now, non-consent is a better standard than the one we had.
Right.
But is it a transitional standard? Should we have other standards? And there's discussion there, for example, in terms of participation and mutual participation, or discussions in terms of structural discrimination that the transactional consent element could not be included, perhaps. So I think those discussions are also already have been happening for a long time. And I think perhaps in the near future, they will also gain more space. I think definitely there's also a move towards the yes means yes model between different social movements across the world. And I would like to perhaps end with a tension that I have while researching this topic. I believe in researching these topics because they are about violence, they are about making suffering and harm towards people. So that's why I am working in these topics, and I consider a lot speaking about human rights and sexual violence and discrimination. At the same time, because I'm doing it within a criminal law framework, I have a tension because I also believe that criminal law should be as reduced as possible, if it should be, but that's a whole other discussion on abolitionism. So I think it's a tension because from one side we are saying, okay, we need to recognize that sexual violence and rape need to be considered as offenses on these terms. But at the same time, then the criminal law system in many countries, and in Peru, for example, where I'm from, it ends up being applied towards the most vulnerable. So when we discuss sexual offenses, I always also try to keep in mind that LGBTQ people, or people that do not fall within the heterosexual or cis-normative classifications, are probably going to be differently treated by the criminal law.
There's plenty more to discuss and research on this topic, Cristina. Thank you so much for sharing your knowledge with us today, and the very best of luck with your future research.
Thank you very much for having me here, and all the best with the podcast.
Thank you. Thanks for listening to the Lawcast. If you'd like more information about Max Planck Law, or if you'd like to get involved, please visit us at law.mpg.de.
Max Planck Law. Excellence in legal research.